researcher is alone yet to join. Just a minute, we'll call.
Yeah.
Court officer, could you kindly let our researcher inside? Okay, thank you.
Okay, shall we start?
Sure, please.
Neha.
Good evening, esteemed judges and participants. Welcome to National Moot Court Competition Online 2024, organized by Mount Zion Law College Moot Court Society. The preceding judge of the finals judging panel is Senior Advocate Heera, former professor of the National Judicial Academy Bhopal and former Law Secretary of Government of Kerala, and also the former Vice Chancellor in charge of NUALS Kochi and retired district judge. And the first co-judge is Shyam Padman, who is a designated senior advocate of the High Court of Kerala. He is an eminent advocate with more than 33 years of standing at the bar and is widely recognized techno-legal and medico-legal consultant. And the second co-judge is Hariraj M.R., senior advocate, having completed his graduation in law from Government Law College of Ernakulam. He has 25 years of standing at the bar. He established his practice in areas of service law and administrative law and practices before High Court and tribunals across the country, as also the Supreme Court of India.
Please do let us know once the court is in session.
Yes. Shall we? Which is the first team? Petitioner's team?
Sir, there are some more details. May I continue?
Oh, sure. I thought you had finished.
This is the final round of Moot Court competition. Each team will be provided by 35 minutes, 30 minutes for arguments and 5 minutes for rebuttal. And in every 10 minutes, there will be a reminder given by the executive committee. The judge have discretionary power whether to extend the time, and the judge's decision will be final. The teams participating are MEZL NMT 005 and MEZL NMT 006. Handing over to judges.
Very good evening to all of you, and my brother judges, the speakers speakers were the petitioner and the respondent. So, as we understand, see, when you make your submissions, make it very clear and precise so that we'll understand. And suppose we put a question to you, please understand the question and then answer that question, because then alone we'll be able to understand how articulate you are, how you are able to present your case. And now I ask you, the speaker one of petitioner's team, to go ahead with your submissions.
Much obliged, Your Lordship. Lordship, am I both audible and visible?
You are.
Thank you, Lordship. Lordship, this is the council appearing on behalf of Nilgiri Innovations in the case of Nilgiri Innovations versus the state of Aryavarta. Would your Lordships appreciate a brief perusal of the facts of the present case?
Yeah, you can.
Concisely, you can say what the facts.
Much obliged, Your Lordship. Nilgiri Innovations is a startup company which is based in the state of Aryavarta. They developed an AI-driven tutoring platform by the name of EduTechie, which was widely accepted in schools. state of Aryavarta filed a claim for infringement of copyright in the trial, stating that order for injunction and issued damages also, Your Lordship. So this was with regards to what had happened in the Nilgiri as a state of Aryavarta. Simultaneously, there was another petition being filed by one Scholars Alliance before the Supreme Court of Bharatpur, which is the country. So this petition is challenging the constitutionality of Section 52 of the Copyright Act, which deals with fair use. Nilgiri Innovations went via an appeal to the High Court of Aryavarta, and the Supreme Court, when the petition filed by Bharat by the Scholars Alliance came before it, decided to club these petitions together and transfer the case from the High Court to itself by exercising its jurisdiction under Article 139A. So presently, both these matters are posted for hearing. I will be representing Nilgiri Innovations, and my co-counsel will be representing the Scholars Alliance. And we may differ in our argument with relations to fair dealing, Your Lordship, but we are presenting together as a team for the sake of brevity in the competition. Your Lordships, can the council proceed to the issues I'll be dealing with?
Yes. Before that, this is a now we are under Article 139 and
Yes, Your Lordship.
of the Constitution. So we don't have to look into the facts of the case, and we need only answer the question of law which is raised in the constitutionality alone, and then the matter will be remitted to the courts concerned for their decision. So I think it would be enough if you just state the bare facts and the legal aspects of this. Is it not?
Much obliged, Your Lordship. The council will refrain to only the minimal amount of facts as well.
Yes.
Your Lordship, the council personally will be dealing with two issues. Firstly, whether the educational materials were in the public domain at the time of their use, and whether the educational materials, state-developed educational materials, can be protected under the Copyrights Act. And the second issue being whether the state's claim of proprietary rights affects the right to conduct business under Article 19, Clause 1, Clause G of the Bharatpur Constitution, Your Lordship. To deal with the arguments of the first issue, council will be first dealing with with what has been impugned, the impugned material which the state has claimed to have been infringing. State has claimed their copyright has been infringed over. Firstly, Your Lordship, if we refer to the moot proposition, paragraph 3, it clearly talks about core algorithms and certain educational content, Your Lordship. So the council will be breaking down the copyrightability of core algorithms and then this educational content as well, following by proving that there is no case of infringement met out in the present case. Okay. With regards to the algorithm, Your Lordship, there is a very basic principle in with copyright law, which is that there's an idea expression dichotomy. An idea cannot be entitled to copyright protection. It is only the expression of an idea which can be protected under copyrights. The same has been held in the case of R.G. Anand versus DX Films, where two parties tried to take a movie out of a similar concept, a historical event, and the court ruled that the copyright would not subsist for the historical event, but it would subsist for both of their movies, which counts as an expression of this event. Taking the same into account, Your Lordship, it is important to understand what the definition of a core algorithm means. The first ever case which properly defines it is the Gottschalk versus Benson, which is one of the three famous trilogy of patent cases which happened all the way back in US. Indeed, yes, Your Lordship, algorithm was first defined in the context of patents. In that case, the court held that an algorithm is a set of procedures for solving a mathematical problem. This was the contention all the way back in 1960. Following this, there were multiple developments. In 1994, the WIPO Copyright Treaty was enacted, which also in line with the TRIPS agreement, which both of these recognized computer programs as part of the copyright protection, Your Lordship. So taking this into account, what an algorithm is basically a set of procedures. It is not the actual outcome or the program, Your Lordship. The program or the software would have been the expression. The algorithm is merely the idea in the present case. So the state trying to claim that they own proprietary rights over a copyright over an algorithm is absolutely false here, Your Lordship. So taking this into account, the council would like to cite the case of SAS Institute Inc. versus World Programming Limited. In this case, the court observed that an algorithm is merely an idea for an expression which would be the program software. And just like in the case of R.G. Anand versus Deluxe Films, although the algorithm is similar, the fact that there are two different possible expressions of the program is enough of a criteria for a right of copyright to subsist in both of them. Firstly, your lordship, it is humbly submitted that state did not develop any software in the present case. It was only Nilgiri Innovations that ended up developing the software. So the copyright, if any at all, which exists, should be with the
Does
software.
this RG Anand's case, does it deal with algorithms?
Your lordship, that talks about the idea expression dichotomy. The present case which I have cited, which is SAS Institute Inc. versus World Programming Limited, it deals with algorithms, your lordship. And additionally, the trilogy of patent cases also have held algorithms are not entitled to IP protection, your lordship.
Why do they say that algorithm is not?
Your lordship, as I had just stated, copyright exists for an expression of an idea. It cannot exist for the idea itself. Your lordship, the council would like to give an
Council, just one question. We are dealing with artificial intelligence or computer database, or at least software. Where
Yes,
under Copyright Act is it defined? Is it which it comes under which category?
Much obliged, your lordship. Section 2, clause FFC defines computer programs, and under copyrightable work also, computer programs have been included under the definition of literary works, your lordship.
That is what exactly I am asking. It comes under literary work.
Indeed, yes, your
So
lordship.
all those parameters are applicable as far as copyright infringement is concerned. Of literary work alone applies in this case.
Absolutely, your lordship.
Mm-hmm.
The
A
council would
software or an algorithm is akin to some idea, this literary work, because it's a diagram. That is why it comes under the copyright. Otherwise, it would have gone under the Patents Act, is it not?
Your lordship, with regards to software or software per se, it can be either patented if it has a novel and innovative step, or it can be subjected to copyright protection as well, just for the existence of the program in bare text, your lordship. That counts as literary work. An algorithm is only an idea. Patent Act specifically excludes the protection for algorithms. In Copyright Act, nowhere is the word algorithm even mentioned, your
So,
lordship.
is it your case that of the petitioners that algorithm is some strange species which can never be protected under any intellectual property law?
Your lordship, the petitioner is humbly submitting that algorithm is merely the idea. The expression of an algorithm is the program. So the program is entitled to be protected. Algorithms can be protected, your lordship, provided they are associated with a patent protection for a software. That is the only way in which algorithms have been protected up until date, your lordship. So the state doesn't have any patent protection, nor do they have a software to begin with. It is Nilgiri Innovations which developed the software itself, your lordship.
How was it found that the lower court found that there was a violation or rather infringement, copyright, and injunction and damages were granted? Basing on what that was granted? I mean, was it the source code? Was it something like duplication of something else? Was there any replication in the software?
Much obliged, your lordship. Your lordship, the moot proposition fact sheet is silent on the matter. However, relying on the
See,
claims.
council, what is stated is you have used the core algorithm developed by the state.
Your lordship,
Look at the problem, paragraph number 3.
yes,
Alleging that core algorithm, we will skip the rest of the thing, derived from proprietary material developed by the state. So the core algorithm you are now relying on, or the so-called idea that you have taken, is from some material that has been developed by the state, is the allegation.
So there is a tangible thing there because it is developed and it is not just in the realm of thoughts. Like you said, all the decisions you cited were regarding the dichotomy between just a mere idea and something abstract and concrete. Simple as that. So here is something concrete. So could it not be protected? Forget about the infringement factor. Your core argument that this cannot even be looked into,
your
can it be
lordship, the
sustained?
council would like. Your
Yeah,
lordship, the
please.
council would like to cite an example to prove the same as well for your reference, your lordship. Well, let us take, my goal is to make a program for multiplying two numbers. I could write an algorithm wherein I will give instructions, take the first number, add it to itself the second number of times. So if I'm multiplying 2 times 3, I will add 2 to itself 3 times. This is an algorithm, your lordship. If I write a program for it, I could make it either direction. I could either first take up the first number, add it to itself the second number of times, and I could write a program for that. Or I could compare the two numbers. I will now find out the second number is actually bigger.
Council, one straight question.
Yes,
Is
Your Honor.
the term algorithm defined anywhere?
Your Lordship, in Patent Act only it has been defined with relevant to intellectual
Petition,
property. There
10
also
minutes is over.
thank you, Court Officer. It has been defined in the Patent Act, and there it has been defined as something that would not amount to an invention, Your Lordship.
What is the dictionary meaning of algorithm?
Well, Lordship, the dictionary meaning per se is that it is a set of procedures used to solve a mathematical problem, Your Lordship. It is just giving the procedure. As to how the procedure is being expressed is can be seen only through the program or the software, Your Lordship. So the program or software is what is entitled to protection.
The example you cited, writing in a piece of paper, 1+1, etc., is it not an
Yes,
expression on a tangible one? Could it not be protected?
Your
It's a
Lordship.
end of the day, it's a literary work.
Your Lordship, much obliged, Your Lordship. That would apply in the present case as well, Your Lordship. If we assume that the state had actually fixated their literary work on some tangible medium. However, Your Lordship, this the council would like to talk about something called doctrine of merger, Your Lordship. If the idea and expression are so intrinsically connected that they cannot be separated, copyright protection for the same will not exist. In the present case, the goal of both the parties, assuming the state wanted to develop a software, was that to make a AI platform for the purpose of teaching students. It has to be interactive, it has to have education materials. So all of these are common goals. The idea and the possible expression of it was so interconnected that the state cannot claim a copyright over their algorithm alone, Your Lordship.
We can see your friend eagerly waiting to submit. So, I mean, so that to avoid overshooting the time, in 1 minute, could you just give the quintessence of what exactly is the point you're trying to impress upon us?
Your Lordship, an algorithm is an idea and not the expression of the idea. The expression of the idea would be the program developed by Nilgiri Innovations. So Nilgiri Innovations would have been the rightful copyright owner. We are not claiming copyright infringement anywhere. The state has wrongfully claimed copyright that we are infringing upon their proprietary rights in the present case, Your Lordship. So that is with regards to algorithms. The Lordship is satisfied. The council would go on to the expression for educational material, Your Lordship. Much obliged, Your Lordship. With regards to the educational material, firstly, Your Lordship, there is a question of whether it is dedicated to a public domain. Although the educational material developed by the state is freely accessible to all, it is available in the public domain. But the council does understand that even though something is accessible in the public domain, that does not mean anyone is allowed to misuse the same, Your Lordship. In the present case, it has been dedicated to the public domain, Your Lordship. Dedication is the process where a party relinquishes its rights and ensures the copyright of it is available to every single person. This is the state board syllabus and it's the education material developed from the same. So the state has made it to ensure access to every single person in its within its limits, Your Lordship. So the usage for educational purposes is already an exception under fair use. Now the state itself has dedicated what it has made, the educational content, for use of every person, Your Lordship. The fact that our Nilgiri Innovations has taken this educational material, compiled it together, made it in a more accessible and easier to understand form, does not mean that we are infringing upon their copyright. We are merely ensuring there is a better access to education for people, Your Lordship. Taking this into account,
Council, council, you would agree with us that this intellectual property protection or rights has dual purpose. One is to encourage people to invest their time, energy, etc., to invent, to innovate, and bring out something new so that they can encash on it. The second one is that it should not be stifled, and this person should not be given complete autonomy over it because it has to spread. So a balance
yes,
will have to be struck. We are here to decide how the balance has to be struck. You said that the materials were there, we only just took it, made it into a better looking material, we offered to the public. If does that not infringe at least the constitutional right of the other party to have property and property rights, let alone the intellectual property?
Your Lordship, the Council humbly agrees, and in line with the same principles of intellectual property you had just stated, which is that it should benefit the author or the owner of it and also the public at large. There should be a balance of the same, Your Lordship. In the present case, the state has made this educational material. Is it freely accessible to all because the state is carrying out its duty under Article 21A to ensure right to education? The answer is yes, Your Lordship. Any person can open the internet and find
that state need to give it only to the students, not to you. You are using it as a commercial venture.
Indeed, absolutely not, Your Lordship. The Nilgiri Innovations is not doing it purely for a commercial purpose. Your Lordship, our organization was formed for transforming the education experience, Your Lordship. The same is given in proper.
They're taking money, right? After at the end of the day, you take money.
Indeed, yes, Your Lordship. We still do need money to subsist and to make further more innovations here. Your Lordship, if you look at the simple fact that the state is claiming we have copied their algorithm, which means for so long.
Council, are we to understand or take that you are at least at this stage submitting or rather admitting that it is already a creation of X, let it be state, but you only modified it being in free access? I mean, does both the arguments, does it not, are they not mutually destructive? I mean, can you
You went
blow
on to
hot
say that
and
in
cold? Can you
December.
approbate and reprobate at the same time?
Your Lordship, our argument is that even if it was created by the state, Your Lordship, but if we had made very minor modifications to the same, the principle of transformative work would apply, and copyright would subsist for whatever is there on our software as well.
That is if you have got permission from the other side, number one. Number two, the original creator has a right of integrity of his original work. You just
Absolutely.
cannot meddle with it.
Indeed, yes, Your Lordship. The integrity of the state is in no way affected by Nilgiri innovations.
It is not the integrity of the state, integrity of the intellectual property created.
Indeed, yes, Your
State's
Lordship.
integrity we are not going to decide.
The integrity of the intellectual property or any of its moral or economic rights, which is associated with the same, is not affected by Nilgiri innovations, providing a better medium of access to students, Your Lordship. We are merely helping further the goal of ensuring education reaches all people.
Where in the Copyright Act you will get such a permission?
Your Lordship, there is exceptions.
I'll tell you what, I write a poem, you read that, you feel that you could write it better. You could change some words here and there and make it little more better, maybe more rhyming. You take my poem, make some changes, make a little more rhyming, and say that it is a better work, now that it is your work.
Your Lordship, there can be an argument made that the work has been transformed and it is a transformative work under.
How will you transform without my permission, my work? You
Your
agree
Lordship,
that it is my work. You
that
agree
might
that
have
you
been
are
an
taking
idea
it.
for you. Your Lordship, there might have been an idea which inspired you to create the work.
Which provision permits this transformative work?
Just a second, Your Lordship.
The provision, I believe, is you are making students wiser with your vices.
Indeed, not, Your Lordship. Our goal is to only ensure there is a better access to education, Your Lordship. If we look at the fact that the state had the algorithm but still hasn't developed the program, and a startup company that just created the program and it is widely accepted through all the schools, it clearly shows the state could have done a better job. But the fact that we are a private company and we are doing it, the state is infringing upon our right to carry out business here, Your Lordship.
I mean, are you going to sue the state for infringement or are you just defending the suit?
We are not suing the state for infringement here, Your Lordship. We are merely trying to ensure education reaches everyone. The state is preventing us from doing that. They are preventing us from subsisting as an organization carrying out a business without a proper valid claim of copyright here.
But by the past contact and the way in which the matter is presented before us by the records, I think the education of your directors were not proper.
Apologies, Your Lordship. The directors had worked with the noble intention to ensure the software reaches the person. Regardless of how similar the algorithms were, the end goal was to make a software to be able to assist the students for teaching. The algorithms are obviously going to be similar here. The end products are obviously going to be similar here. Your Lordship.
What is the tagline of your advertisement? Hook or crook will make you wiser.
Apologies, Your Lordship. The same has not been given in the package, but our tagline would have been along the lines of improving access to education, Your Lordship.
Okay. Any other point to be urged?
Your Lordship, I'd like to quickly sum up the second issue, which is in relation to violation of right to business, Your Lordship. While the council humbly does acknowledge that the right to business given under 1916 is subject to reasonable restriction for public interest, we have been acting in the interest of the public by ensuring there is a better access of our software to the persons, Your Lordship. After it has been widely accepted in schools, the state stepping in and claiming an invalid copyright infringement upon us is very directly an attack on the right to business of our organization. There is no reason for them to claim a copy of the algorithm here, Your Lordship, and nowhere has the state ever before claimed their algorithms intellectual property rights have been violated. Secondly, with regards to the educational material, it's also, Your Lordship, the mere fact that we develop out of it and the fact that the state is trying to restrict us from do the same is restricting on the goal of intellectual property, which is to benefit the society. We have taken educational material which is available in the public domain, we have developed it, we have transformed it, we have made it accessible in an easier manner. Now the state is claiming that this is illegal, this is infringement of copyright. So this also places a chilling effect on all the other future innovations that will be happening along the same lines as well, Your Lordship.
I mean, the same argument could be used against you. The chilling effect would be that no one else would indulge in any sort of this intellectual exercises if they feel cheated and if their rights are not being protected. What good would be such a state wherein my efforts are not being protected and anybody could have a free walk over that?
Much obliged, Your Lordship. Your
Petitioner,
Lordship,
your
along
10
those
minutes is over. 20 minutes over, 10 minutes remaining.
Your Lordship, the council seeks just 1 minute to answer your question.
Your time starts now.
Yes, Your Lordship. Your Lordship, while the goal of intellectual property is to ensure the protection of author and the society's rights, to protect the author's rights, we have in no way infringed upon the same or violated upon the same as well, here, Your Lordship. Whatever protection the state was giving to the authors of its educational material, the same amount of protection was being given by Nilgiri Innovations in its platform as well, Your Lordship. So we are not discouraging authors from making more productive work, Your Lordship. It is merely an adaptation of what the state has as its syllabus and improving upon it to make a transformative work, Your Lordship.
You could have just relied on the Supreme Court, our own ruling, wherein we say that it's not tax evasion but tax management when you do indulge in activities wherein the tax component could be reduced. Anyway, let's hear from your counterpart also.
Your Lordship, because we are representing different petitions, the council would like to cite the prayer for my petition alone first, Your Lordship.
Please.
Your Lordship. Wherefore, in the light of the issues raised, arguments advanced, and authority cited, it is most humbly and respectfully prayed before this honorable court that it may be pleased to adjudge and declare that there is no infringement of copyright in the present case, and that the order of the trial court was wrong in law, and to strike down the same, and or pass any other order or orders as this honorable court deems fit and proper in the circumstances of the given case and in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioner shall be duty bound and forever praised.
Absolutely. You will be indebted. Justice, equity, and good conscience applies both ways. Yes, your co-counsel, please.
May it please this honorable court. This is counsel appearing on behalf of the petitioners in the case of Scholars Alliance versus Union of Bharatpur. Your Lordship, am I audible and visible?
You are not visible, but you are audible.
You are both. I mean, unfortunately, both. Please go ahead.
Yes. Much obliged, Your Lordship.
You switch on the camera. See, I think you.
I mean, in fact, sir, her camera is on. I think you would have muted that.
Who was muted?
Sir, no.
My camera is not muted.
Sir, she has
gallery.
She has entered from two accounts. Her voice is in one account and her visuals are in one account.
Oh, okay. Because probably Sari is not in the gallery mode, so he
sir, gallery mode like one only.
Okay, right.
And okay. This is double impact.
Okay.
Please.
Fine. Okay.
Much obliged, Your Lordship. Lordship, it is pertinent to note that the Supreme Court has compiled various petitions under Article 139A to address these matters comprehensively, which was stated in para number 7 of the Moot proposition. Given that the issue speaks about the constitutionality of an act of Bharatpur, the appropriate party as respondent would be the Union of Bharatpur, Your Lordship. Now, moving on to the issue of whether the current petition is maintainable, I humbly submit on behalf of the petitioner that it is indeed maintainable. The petition satisfies the essential criteria required for maintainability as outlined in established legal precedents. Before I elaborate further on this point, I will initially address that whether Section 52 of the Bharatpur Copyright violates the fundamental rights and whether it is constitutional, Your Lordship, as it is imperative to assess this violation as it lays the groundwork for understanding the implication of the current petition. So the constitutionality of Section 52 is under scrutiny here due to its extensive exemptions for the use of copyrighted works. This provision raises significant concern regarding its alignment with the constitutional protections for the intellectual property, creators' economic rights, rising concerns about proportionality and public interest. Your Lordship, I will now read through the provision. Section 52 states that the following acts shall not constitute an infringement of copyright, namely, fair dealing with any work not being a computer program for the purpose of private or personal use, including research, criticism or review, whether of that work or of any other work, the reporting of current events and affairs, including the reporting of a lecture delivered in public. As we read through the section, it is evident that it lacks clarity and provides no definition of fair dealing, Your Lordship. The vague language creates ambiguity around what constitutes permissible use, further undermining the rights of copyright holders. This lack of clear guidance ultimately leads to potential misuse and abuse of copyrighted works. Now, arguing on behalf.
Which part of it is not clear to you? A fair
The
deal for the
fair
purpose of certain things. One, it has to be fair.
What do you mean by fair dealing with literary work?
Your Lordship, fair dealing is a limitation and exception to the exclusive rights granted by the copyright law to the author of a creative work, Your Lordship.
The question is fair dealing for a particular purpose. So guidelines are very much there. The purposes for which the dealing can be done, and over and above that, it should be fair also, or rather, it should have a nexus with the purpose. Correct. That is what we understand when such words are used. So why is it?
Yes.
Why is it that you say it is vague?
Yes, Your Lordship. Lordship, there is no proper or clear definition of what fair dealing constitutes of, Your Lordship.
No.
Would we require a definition for fairness?
Now this section is substituted in 2012.
Correct.
Have you seen that? And then in the brackets they have added, it does not apply to not being a computer program.
Yes. That is
What is the significance of that?
Much applies to Lordship. Lordship, there is no clear definition of what research is also, as well, Your Lordship. And
No, that's not my question. That's not my question. My question is, why in this square brackets, not being a computer program used as inserted in the amendment, and what is the import of that so far as Section 52 is concerned?
Pardon me, Lordship. Can you kindly repeat the question?
This would mean that if we are using even a fair dealing for the purpose.
Yeah, Hari, this question is, there is a square bracket. Have you seen the square bracket?
Yes,
Not being a computer program.
Not being a computer program. Why is that placed in a square bracket? And what is the import when a matter is placed in a square bracket by way of an amendment? Because we are now dealing with a computer program, is it not?
Yes, Your Lordship.
This is not a literary, dramatic, musical or artistic work. Have you gone? Have I made myself clear?
Yes, Your Lordship. Lordship, that was introduced because a new provision was introduced for computer program, Your Lordship. Also, I'm not dealing with the computer program issue as it was addressed by the Nilgiris Innovations, Your Lordship. I'm here to represent the Scholars Alliance, Your Lordship.
What? I'm not able to.
Your Lordship, pardon me, Your Lordship. Lordship, I was stating that the issue of computer program was not being addressed by me, but it was addressed by the council from the Nilgiris Innovation, Your Lordship. I'm here to address the constitutionality of the Section 52, Your Lordship.
Carry
on. Much obliged, Your Lordship. Now moving to the arguments on the purview of infringement of fundamental rights under Article 14. The principle of equality before the law is fundamentally antithesis to the arbitrariness. This principle was underscored by the Supreme Court in the landmark case of E.P. Royappa versus State of Tamil Nadu, where it was established that laws must not be equal, laws must not only be equal, but also be applied in a manner that it is just and fair, avoiding any form
you
of.
You are referring to E.P. Royappa's case?
Yes, Your Lordship.
What are the facts in E.P. Royappa's case? And what is the exact principle applied in deciding those material facts in E.P. Royappa?
Your Lordship,
you just can say in 3 sentences.
Yes, Your Lordship. Lordship, in this case, Royappa alleged that
that was a case under the service law, is it not?
Yes, Your Lordship. Yes, Your Lordship.
Yes, it's a very important
Petition,
decision. Just tell me.
petition said 30 minutes to over. Your time is up. Judges can
Let her answer
extend.
this question. We have just given her this.
Okay.
So I just want to understand whether she has looked up all these matters.
Yes, Your Lordship.
Time.
Your Lordship, in the case of Royapa State of Tamil Nadu, the Royapa alleged that his dismissal was arbitrary, unequal treatment, and violation of its rights under Article 14, 16, and 311 of the Constitution, Your Lordship. He
Okay.
accused that the government of issuing orders based on
But you know, you
man-of-fight.
just tell me the principle.
Sure, Your Lordship. The court in this case ruled that the scope of equality under Article 14 of the Indian Constitution was expanded. The court also imposed limitation on the discretionary powers of the executive and administrative authorities, Your Lordship. Also, in this case, it was established that laws must not be equal, but also must be applied in a manner that it is just and fair, avoiding any form of arbitrariness, Your Lordship. I stated this case just to quote that the laws must not be must not only
Revised
be equal, but
commentary.
also.
Move on. Yes, thank you.
Can you just conclude your submissions in a minute or so, so that we can move on?
Much obliged, Your Lordship, moving to the intelligible differentia part, for the concept of
Intelligible differential. Intelligible differential. Intelligible differential.
intelligible differentia. Much obliged, Your Lordship. The concept of intelligible differentia is crucial in assessing whether the classification created by Section 52 are reasonable. The broad exceptions by the use of copyrighted
See,
works.
it speaks about classification. There should be an intelligible differentia, and the intelligible differentia should be for the purpose of furthering the
There should be a rational nexus also.
rational
Right.
nexus, furthering the objects of the act. That is what is used. Anyway, we just conclude that so that we need not.
Yes, please.
Much applies, Your Lordship. What the council was about to say was the broad exceptions for the use of copyrighted works create an unreasonable classification that falls to meet the constitutional requirement of intelligible differentia under Article 14. This lack of intelligible differentia results in arbitrary distinction between the users and the individual creators, as the law does not justify why specific exemptions should be afforded to create certain entities at the expense of others. Additionally, the rational nexus between the classification and the objective sought to be achieved is absent, Your Lordship. The preamble of the Bharatpur Copyright Act aims to protect the author's right while promoting creativity and public access. However, Section 52 disrupts this balance by enabling extensive use of copyrighted works by anyone, even the large institutions, without compensating creators, Your Lordship. Now moving on to Article 19 clause 1 clause A. The Article 19 clause 1 clause A guarantees the right to freedom of speech and expression, which encompasses the control over one's intellectual property. The chilling effect doctrine indicates that overly broad regulations can deter the individuals from fully expressing themselves due to the fear of misuse or infringement. The chilling effect is further illustrated by Supreme Court in the decision of Shreya Singhal versus Union of India, Lordship. The court recognizes that such broad regulations stifle free speech and creativity. Similarly, Section 52's
How do you
vague
compare Section 66 with 52?
Yeah, indeed, yes, Your Lordship. Section 52's vague fair dealing exceptions might lead to creators to refrain from sharing their work or producing new content due to concerns over potential infringement and lack of protection, Your Lordship. Furthermore, these exemptions result in a significant lack of protection and incentives for the work of individual creators, leaving them vulnerable to unauthorized use of their intellectual property. This undermines their ability to control their creations and discourages them from producing original content, ultimately diminishing the overall creative landscape.
So you justify 52 or are you decrying 52? I mean, your last submission that creativity will be stifled, etc. I didn't understand that properly.
Yes, indeed, yes, Your Lordship. I
You
was about
cited
to
this
say that.
Chintaman Rao. Okay, what was banned in Chintaman Rao? Manufacturing of what?
Pardon me, Your Lordship, can you repeat?
Yeah, you have cited this Chintaman Rao was the state of Madhya Pradesh. What was the substance which was monopolized or banned in Chintaman Rao?
Manufacture of BD, Your Lordship.
I just wanted to know. Okay, thank you.
You can, if you don't have any other points to be made, just clarify the last statement you made, submission, wherein you were making statements. We were I mean, unable to understand whether you were trying to support 52 or you are trying to say that it's bad. I mean, what exactly is your
Uh,
point?
yeah, definitely, Your Lordship. I will repeat what I was
No,
trying
no,
to
don't
convey.
repeat. Just tell us what it is.
Sure, Your Lordship. I
Are you
was
saying
saying
whether
that
it is constitutional or unconstitutional?
unconstitutional, Your Lordship.
Okay, why unconstitutional?
Yes, Your Lordship. As the vague Section 52's vague fair dealing exceptions might lead the creators to refrain from sharing their work or producing new content due to concerns over potential infringement and lack of protection on Your Lordship.
So
Furthermore,
if 52 goes, your act will be even more strictly construed. The state will have a better case against you. 52 is your shield according to us.
Shyam sir, it seems that they are both appearing for two different parties.
Okay, so you are only for the creators. Oh,
He,
yes,
he is
yes,
for the creator, so she has already abandoned him from the very beginning. The
See,
okay.
co-counsel,
again,
Thankfully,
you
they
did
are
not
not sitting
answer.
together.
You did
Otherwise,
not.
they would have beaten up each other.
You harped on this fair dealing, but
Hmm.
the section says fair dealing with any work not being a computer program for the purpose of.
That
they need
aspects
to say
you
that
had
even
all
that is
earlier
not
asked.
permitted.
That of course she will come back to us during the clarification. I hope in the last
Okay.
5 minutes. You better look up that. So I mean, are we to understand that you appear for a party who creates?
yes, Your Lordship.
The creators want their creation to be completely within the domain and protected.
Yes, Your
And
Lordship.
your
Yes.
apprehension is that 52 is such a what do you call broad based and vague and what do you call something that cannot be sustained because it can't be properly implemented, and even if implemented there will be loopholes and other things which the other unscrupulous persons according to you, I mean your co-counsel's client, may take advantage of, right?
Yes, Your Lordship.
That exactly is it. Anything else to be stated so that we can go to the other side and enlighten on what exactly they would like to say?
Sure, Your Lordship. Maybe I will wrap up my arguments in just 1 minute, and I will move on to my prayer, Your Lordship.
Prayer you can leave because prayer we are read it because and anything else you will be indebted forever. Don't, please.
Much obliged, Your Lordship.
You
So,
just
wrapping up.
just make a final submission here.
Yes, Your Lordship. Wrapping up my argument by finally stating the infringement under Article 21. In the present case in hand, the deprivation caused by Section 52 of the Bharatpur Act clearly violates the right. The determination that this deprivation fails the tests of a fair, just, and reasonable law is grounded in the legal framework established by Supreme Court in a plethora of cases. This framework emphasizes the need for not only procedural safeguards but also substantiative due process, holding that any law affecting life or liberty must meet the standards of reasonableness. Specifically, it must not be arbitrary, and the means adopted must serve a legitimate purpose without disproportionately burdening individuals. Your Lordship. If your Lordships have no further queries, I will leave the podium to the respondents. Your Lordship.
And court officer, whatever extra time they have taken, that may be provided to the other side also in the fairness of things.
Yes, I have noted the extra minutes.
Yeah, please. Yeah.
Yes, please respond.
Good evening to the Honorable Bench. If it may please, the Council seeks permission to address the bench collectively as Your Honor.
Absolutely no issues. Whatever you call us,
Please, please.
please proceed.
Much obliged, Your Honor. This Council, representing the respondent, is appearing before the Honorable Court in the matter of State of Aryavarta versus Nilgiri Innovations on behalf of the respondent under the Supreme Court of Bharatpur. With Your Honor's permission, may the Council proceed with the facts of the case?
You need not seek permission every time. You can just make your submissions. No issues.
Much
It's a
obliged.
free country. It's an open court.
Much obliged, Your Honor.
Now you make it concise because facts we know now.
Indeed, Your Honor. Aryavarta, a state in Bharatpur, filed a suit against the appellant Nilgiri Innovations alleging a copyright infringement on its educational software EduTechie. In that, their proprietary algorithms and content developed by the state's Department of Education are infringed. The trial court ruled in favor of Aryavartha, finding infringement under the Bharatpur Copyright Act 1957, issuing damages as well as injunctions. Now, Nilgiri Innovations appealed, claiming the materials were public domain and that the rulings violated their fundamental right to conduct. So the High Court has been transferred to the Supreme Court alongside a related case challenging the constitutionality of Section 52 of the Bharatpur Copyright Act 1957, which was filed by yet another party, that is Scholar Alliance versus Union of Bharatpur. Your Honor, there are three main issues in the present matter. The Council will be dealing with the first and second issue and would be speaking for the first 22 minutes. And my co-counsel would be dealing with the third issue and would speak for the remaining 8 minutes, respectively reserving 5 minutes for the rebuttal. The Council seeks permission to proceed with the pleadings.
Please do.
Yeah,
Don't seek permission. You just carry on with your submissions.
Indeed, Your Honor.
Maybe our mindset may be in such a way that we'd say no permission granted. So don't take the risk. Just finish it.
Your Honor, I appear before this honorable court on behalf of the respondent.
That we know. You just tell us what the facts.
Who are you representing? The state of Aryavartha?
Yes, Your Honor, the state of Aryavartha. The
So
respondent.
before proceeding further, does not or is it not the priority of the state that more and more students get educated, they are enlightened, or do you want to have a citizenry who are ignorant and incapable of taking educated decision making, participating in an educated decision making process? Why do you want to have this, even contest this matter? Because end of the day, it all revolves about education and education materials.
Thank you, Your Honor. Your Honor, state indeed wants a legible and worth students, that is youth must be educated, and that is the public welfare, that is what the state upholds. Now, in the present case also, the state has not, the state is not claiming, or state has provided the educational materials, and there is public accessibility of the educational materials in the present case as well. It is what the state is trying to claim here is that
Council, the final purpose or the final targeted group for both the softwares, or if I may address it as software, the product is to educate students.
Yes, Your Honor.
If the state had succeeded in its endeavor, can anyone ever even step into that arena? Because there won't be any demand for them. The very fact that they were able to make inroads, they were able to sell it, is it not because there is a vacuum created on account of inaction on the part of the state?
Your Honor, Bharatpur being a democratic country, competitions are a part of this.
So you want a competing extra constitutional body to compete even for governance. So you won't discharge your duties.
No, Your Honor. What the council is trying to establish is that innovations is always accepted by the state, but it must not be at the expense of violating somebody else's intellectual property. That is our copyright infringement. That is what the state is trying to establish, because state is the owner of the copyright, and thus, even though the state want to educate the students, educate the youth, but at what cost? That is the only contention that the state is trying to put forth, Your Honor. Your Honor, the council respectfully submits that state of Aryavartha's Department of Education is the first owner of copyright of the educational content in question under section 17D of the Bharatpur Copyright Act 1957. If with the bench's permission, the council would like to quote it. This section provides that in the case of government work, government shall, in the absence of any agreement to the contrary, be the first owner of the copyright. Similarly, under section 28 of the Bharatpur Copyright Act 1957, the terms of government works are also defined, which states that in the case of a government work where government is the first owner of the copyright shall subsist until 60 years from the beginning of the calendar year, next following the year in which the work is first published. So Section 17D read together with Section 28 enlightens us or makes the conclusion that or reveals that the state has exclusive rights over the educational content in question and that the appellants have indeed infringed the same.
How do you meet the argument saying that there is nothing to be copyrighted or intellectually protected? There is it's only a mere idea.
Your Honor,
You are quoting these two sections on the premise that we'll have to presuppose that whatever that has been reproduced or whatever that has been infringed or taken away is something that is copyrightable under the Copyright Act. Under which provision?
Your Honor, the materials in question are literary work, which are copyrightable, and the council, the opposite council, the appellants have infringed the same because the
You mean to say whatever is published in your website is a literary work?
Your Honor, there is literary work within the software published, the works published by the state's Department of Education, Your Honor.
If the state is publishing enough, then why would somebody try to buy it from some private firm? It is obvious that you are making something, claiming copyright and sitting over it. You are not disseminating it to the public in the proper manner. That is why somebody else is encashing on you. And now you will prevent that also so that people will not get any access.
And you want this court to uphold your inaction, incapacity, and inability to give good governance to at least to the impressionable children.
What you are trying to protect is your statement in the website that the content is owned and controlled by the state, protected by copyright laws, and the content can be downloaded, but it cannot be used for commercial use. So anything which is published in your website, for instance, acts, there will be several matters. All these matters will be part of your copyright. But what is exactly the copyright which you are claiming? Which content? Have you stated that in your suit?
Your Honor, specific content which are
state
education.
What is the specific content?
The educational content. That's basically what the moot proposition has upheld, and so the educational content in question is definitely copyrighted.
What do you mean by the educational content?
The content that is initially framed by the state or the trying to establish, or the state was the owners, Your Honor, and Your Honor, if I would like to take an example, for example,
assuming that there is a textbook published by the NCERT, can the NCERT claim copyright over the textbook because it will be drawn from several sources?
Your Honor,
and just a hypothetical question. NCERT publishes a book and then it is put in their website and they say that this is a copyrighted material. Nobody shall make use of this. Can there be a copyright of that nature?
Your Honor, see, there must be a level of creativity in the next work. Otherwise, it would be infringement, Your Honor.
That exactly is the case. The petitioner side say, just take another example, anthology of poems or short stories. The very manner in which I arrange these things, I take it from Kelly, Shelley, or for that matter, many others. But my intellectual input of arranging it in a specific manner and publishing it as an anthology itself, does it not give me a separate copyright over it? And how do you, the state, say that their act is? They were saying that they improved, they have made it more customer friendly, obviously, because that's why there is a demand for it. Had your product been really good, I don't think any discernible parent would ever even think of having a private parties thing coming into the child's room.
10 minutes over, 20 minutes remaining.
So let us continue. Let us answer that. The question put and the answer, we'll remove it from the time frame.
She has 22 minutes. Okay, tell us.
Please
Your Honor, the copyright material that we're talking about, the only contention the state is trying to put forward is that this was done without license. The opposite party has not taken a valid license.
Not the question. You just try to answer the question.
They say they have made changes making it more friendly.
Yes, Your
So
Honor.
that is their work now. That is the
So
question.
for instance, see, we have you seen the SEC,
Yes, yes, Your Honor. Yes, Your Honor.
Supreme Court cases?
Yes, yes.
The judgment, there is no copyright, but they have a particular way of
Head noting and things like that. All that.
so that you cannot replicate. So you can take the judgment. You on that head note and the manner in which they have framed the pages and all, they have got a copyright. That is what the Kerala High Court has held in KLT's case, and that has
Yes,
been
Your Honor.
upheld in the Supreme Court also in another case. Not the law reporting. So that is exactly what my brother judge just asked you.
Yes, Your Honor. The judgment as such belongs to public
No
domain, and
judgment, your case, educational textbook, because from various sources it must have been collected. From your own source also they will collect it. They have their own pattern of publishing it, and so far as your textbooks are concerned, it may not be material which you yours. It may be Wordsworth's poetry, which is some commentary or something like that, written by somebody. For instance, Susan Sontag. They are also footnoting it and publishing it. Can we say that there is copyright in that? They
Your
have a
Honor,
copyright or you have a copyright in that? Nothing can you say that nothing can be used? That is what my brother has asked.
Your Honor, there is private, that is, Your Honor, public accessibility, the state has provided public accessibility not for commercial exploitation. That is the contention that the state is trying to put forward. The NCRT or the state developed algorithms, state developed educational content, sorry, Your Honor, state developed education content might have references from the public domain, but there is enough and more creativity within the state developed materials itself, and that comes under the that is copyrighted, Your Honor. And as per section 51,
Has the state sustained any loss because you are not commercially marketing it? Are you?
Your Honor, this is for this is a protected access, that is.
No, let us forget about protection and all that. I mean, there can be damage without injury and injury without damage. The basics we have learned all that. I mean, I'm only asking you, is the state indulging in any business in this material?
No, Your Honor, this is for public
If
welfare.
if we are not indulging in any what do you call business, there cannot be any loss or damage to you peculiarly, because whatever they do, they might have unjust enrichment, but there need not be any corresponding loss or injury or damage to you. Then how the lower court awarded you damages?
Your Honor, we believe that since there is no license being taken by the opposite counsel, there might be a verbatim reproduction, and there might not be, the opposite counsel might not have produced a creative work, Your Honor, and it would be completely a verbatim reproduction.
Let us agree with your proposition that they have sinned. They are liable to be punished. But how is it that you are entitled to get a benefit out of somebody's sin when there is no loss, damage, or injury sustained by you?
Your Honor, I believe that the trial court has taken the oral arguments as well as the documentary evidences. It is well taken into the ambit of the trial court, and they've granted us the injunctions as well as the damages. So we've the council representing the state of Aryavartha has proved in the trial court that there is no creativity in the work of the opposite party, and that is why injunctions and damages have been granted to the state of Aryavartha, Your Honor.
That exactly is under challenge before us right now, right?
We
are supposed
to defend the appeal is that the trial court has held in some manner. That is what we are appreciating now. Whether that is correct or not is the question.
Yes, Your Honor.
Is it possible for you in this case to say that even though you don't have any commercial loss, you are entitled to get damages?
Your Honor, yes, indeed, Your Honor, because according to Article 51, if somebody exploits your work, copyrighted work, you are definitely, that is copyright infringement. And for copyright infringement, according to Section 55 of the Bharatpur Copyright Act, civil remedies are definitely granted, Your Honor. And civil remedies include injunctions.
What is the next point you want to make?
Your Honor, these are the contentions that the council would like to put forward in the first issue. The council would like to conclude the first issue if the bench may allow.
Yes.
Don't ask permission again. We may not allow.
I'm really sorry. In the light of this favorable ruling from the trial court, we respectfully submit that Nilgiri Innovations have infringed the copyright claims of the state, and that the state of Aryavartha is the first and original owners of copyright in the proprietary materials in question, since it does not belong to the public domain.
Thank you, counsel. Next.
Yes, Your Honor. Now, about the second issue, Your Honor. As Your Honor is aware, the instant matter has been merged with yet another case, that is Scholars Alliance versus Union of Bharatpur, concerning constitutional validity of Section 52 of the Copyright Act.
Are you saying that Section 52 is unconstitutional?
Your Honor, if you're talking about the memo that we have submitted, there has been a technical issue which the council, I'm really sorry, Your Honor, it was found later, even after the submission. So we believe that in the oral arguments,
No, we were under the impression that the respondent changed sides.
No, Your Honor. It's just.
We are only concerned with your oral arguments. Just leave.
Thank you so much, Your Honor. Thank you so much, Your Honor. So Section 52, definitely the state will never say that a central law is invalid, Your Honor. The state definitely upholds the constitutionality of Section 52, Your Honor. There was a genuine mistake in the memo, and we are really sorry.
You forget about that and just come to the point.
Tell us
thank you so much, Your Honor.
You contend that it is constitutionally valid.
Yes, Your Honor. Yes, Your Honor. Because it maintains a balance between the protection of intellectual property rights and constitutional rights. Now, according to Section 52, it embodies fairness, public access, and social welfare. The section carefully lays out specific exceptions where unauthorized use of copyright material is permitted, only fair dealings for private or personal use. That is, for educational purpose or research purposes are allowed. Now, the council would like to draw this honorable bench's attention to a few important sections within few important clauses within Section 52. Section 52 clause A talks about fair dealing with any work. First point being private or personal use, including research. So again, the word private or personal use has been used here. Similarly, Section clause C of 52 talks about incidental storage of a work which has not been expressly prohibited by the right holder. So again, not expressly prohibited by the right holder. Similarly, if we take a look into 52D, reproduction of any work of a judicial to Section H, publication of non-copyright matter with bona fide intention for instruction use. So again and again, the 52 is dealing with fair use doctrine only. These exceptions are for non-commercial use or for private use with bona fide intention for instructions and not for commercial exploitation as
Council, what exactly is the grievance of the state regarding, let us assume that there has been misuse or use of whatever thing you have developed for a particular purpose. They, of course, without a formal arrangement or agreement with you, they are also doing the same thing. They are augmenting, they are spreading, or they are, the reach is more when they come into the picture. What exactly is the grievance of the state?
Your Honor, we uphold constitutionality of Section 52 and claim that Nilgiri Innovations have violated the infringement because they have taken the
20
argument
minutes or 10 minutes remaining respondent.
Yes, Your Honor. So Nilgiri Innovations, since the cases are now clubbed together, we believe that Nilgiri Innovations might have used the only link between this case and Nilgiri Innovations is that Nilgiri Innovation would have used 52's exception to claim that they have done a fair dealing. But in our case, or if we take a look into Section 52, it is constitutionally valid. There is nowhere in Section 52 it is mentioned that commercial exploitation is valid.
What about 52J?
Your Honor, that is mentioned that it's limited to staff or students. So that is a limited access, Your Honor. Again, it is
52J. 52J.
Yes, Your Honor, that is the performance in the course of activities of an educational institution.
Mm.
Yes, Your Honor, that is also limited. That is also limited to the personal use or to for instructions, and this is a rather commercial exploitation where a company or where a startup has
So
purely.
if we understand you properly, you say 52 stands.
Yes, Your Honor.
They say 52 may or may not stand. If
Yes.
stand, they say they are exempted under certain categories. So that exemption, if stands, it agitate and militate against the stand of the state. 52 stands, and if they can show that it comes under any of these subclauses, there is no issue, right?
Your Honor,
So
there
look
is.
at this 52. I don't know why they are also challenging 52. 52, where is it said in 52 that commercial exploitation is not possible?
Your Honor, if we take a look into 52K, recording to be heard in public, we find that the second point, as part of activities of club or similar organization which is not established or conducted for profit. So the word for not profit is mentioned.
Where is it still?
Your Honor, 52K, second point. 52 clause K, subclause 2. Similarly, 52L.
No. K. See, do you have a case that they are what do you call educational materials produced by you are recorded and it is being what do you call permitted to be heard in public by utilizing it? Subclauses comes only when the main clause applies.
Yes, Your Honor, we're validating the same, Your Honor.
How do you say that 52K applies?
Your Honor, we're trying to prove that 52K is
Causing of a recording to be heard in public by utilizing it. Now, suppose I'm singing I've got a song. That song is played in. If it is a copyrighted song, I can't play it in the open, but I can take the lyrics and sing it in my own way. If suppose it's a poem or something like that, is it not? That does not have anything to do with your. Does it have anything to do with 52K?
Your Honor, if it is not for profit.
Can you read 52? You read 52K once more carefully. The
Yes,
causing of a recording to be heard in public by utilizing it. So
Yes.
there is no recording in your case.
Your Honor, 52K subclause 2.
You're
Your
muted.
Honor, you're on mute, Your Honor.
I'm sorry. See, other than K, do you have anything? K cannot and will not apply, and we cannot agree with you.
Your Honor, 52L also deals with the same.
Then should we start from A onwards?
No.
You tell us where in 52 commercial exploitation is prohibited. Not safe.
Your Honor, it says given to non-paying audience, not profit-driven, non-paying audience.
Which section? Which subclause?
52
Which clause?
subclause L, Your Honor.
L deals with something else.
Performance of a literary or dramatic work if the performance is given to a non-paying audience.
See, because the literary work has got different connotations, different nuances. You cannot take it out of the context. Here it's performance of literary, dramatic, etc., etc. So
I write a novel. You make a movie. My novel is made into a movie. It's not possible.
Your Honor, if the novel is written by somebody else, then without their copyright, how
Correct.
can it be converted?
How does your matter come in within the ambit of L? That's what I am asking. You're publishing something in your website. How does that come under the 52L?
Your Honor, Your Honor, the contention is that Nilgiri Innovation has taken the stand that there is the 52 is unconstitutional and that
basically what I understand. Now only I have understood the entire case. Basically, we don't know on what material exactly the parties claiming copyright. They just say that something published. So we are assuming that it's something like the NCRT. NCRT has published a lot of things, their study materials and all. And according to my primary understanding is that NCRT has collected these materials from, then codified it and published it. They cannot have any copyright on those materials, use of those materials in a different way. That is my understanding.
Your Honor,
so your L will not apply because your education institution would not have published a novel.
Counsel, are you contending that their action is violative of the Copyright Act because it does not come under L? Is that the contention?
Your Honor, that is a condition of Nilgiri Innovations, Your Honor, that the fair use, they've used fair use doctrine as
No,
the.
so I mean, I will reframe the question. So, according to you, none of the acts comes under the protection or exceptions under 52. So
52.
they have, yes, so they have committed infringement.
Your Honor, they've exploited it and is contending that
That's
it is
what.
under the exception, or rather,
The question was in your favor, counsel.
Anyway, the state would like to agree with the opposite party. No, no. Okay, how do you conclude the second point, please?
See, what my question was, you did not understand.
Your Honor, could you please?
See, that's why at the beginning I said you listen to the question and give a answer.
Anyway, conclude.
Yeah, carry on, carry on. We'll just.
Yeah, just
Don't worry.
your point number 2. Can you just conclude so that?
Yes, Your Honor. Your Honor, since the state has made substantial investment in developing copyright materials, Nilgiri Innovations have used it for commercial purpose, and it cannot be justified under any exceptions laid down when Section 52. And since commercial exploitation is outside the scope of fair use, so in conclusion, Section 52 is constitutionally valid, grounded in the principles of equality and fair speech, free speech, right to life. However, Nilgiri's actions do not fall within the exceptions laid out in Section 52.
Fine.
Thank you.
Thank you, Your Honor.
Your co-counsel is also defending the state, right?
Yes, Your Honor, for the state.
Yeah, definitely. We would like to hear also.
Please. Co-counsel.
Your Honor, with the due permission of Your Honor, the Council may now address the issue of whether the state's claim infringes Nilgiri Innovations' constitutional right to conduct business under Article 19, Clause 1, Subclause G of Bharatpur Constitution. The Council would like to humbly submit that the claims of the state, claims of the state that they do not violate Nilgiri Innovations' right under Article 19, Clause 1, Subclause G. The Council would like to humbly submit that the rights which are granted under this particular article, that is Article 19, Clause 1, Subclause G, are very specifically limited to the citizens as defined under Section 2, Clause 1, Subclause F of Citizenship Act 1955. And Section 2, Clause 1, Subclause F of Citizenship Act actually defines who is considered a citizen, and this does not include corporation, companies, or associations. Therefore, Nilgiri Innovations as a startup do not fall under the scope of citizen, and they are not entitled to invoke the rights which are rights under this particular article. And this position.
Suppose a group of persons form themselves as a company, they will lose their fundamental rights. That's what you say.
No, Your Honor. The shareholders and of the company can retain the fundamental rights, but as an entity.
Is there any Supreme Court decision which has taken a different view? To my mind, there is a Supreme Court decision because I cannot locate. It was authored by Chief Justice Mahajan.
Sorry, Your Honor, the
On educational, I think educational trust matters itself. If parties, I think newspaper matter, Sakal newspaper or something like that. I don't know where cited. If you form a company, then you will lose your fundamental right. That's what you're saying.
No, Your Honor, they will not use because they are natural persons.
And 30 minutes over, but I'm going to award you 9 minutes extra because the opposite team also was given 9 minutes.
Okay, no problem. How much time they got?
9 minutes extra.
Yeah, sure, please.
Thank you, Your Honor. Your Honor, I'm contending that the rights of a natural person is upheld, but the question pertaining in the particular case is the constitutional right of the entity Nilgiri Innovation rather than the shareholders of.
Counsel, you filed a suit.
Yes, sir.
The defendants of the suit were determined by you. You did not implead any of his shareholders for that matter. You only impleaded the company. Now the company says that our shareholders' rights are affected. against your suit, against your claim, then you say that it is a claim by the company. That is too much.
Being the dominus litis and the person who was in charge of the suit not having steps, taking steps, can you take advantage of your own failure?
No, Your Honor. The count, uh, the council would like to state that.
You can go ahead with the next contention so that we save time.
Thank you, Your Honor. Furthermore, Your Honor, the state's action are well within the reasonable restrictions under Article 19, Clause 6, and the state can say that they have taken the necessary step to protect its proprietary materials, which was actually developed using the state.
You are under 19G.
Yes, Your Honor.
19G. So there should be a law. If the state is appropriating it to itself, all the rights of the citizen, there should be a law passed, is it not? Just look at 19 section Article 19G, the second.
19 clause 6.
19 clause 6, second part of it. There should be a law, is it not?
Existing law or passing any law.
Your Honor, the council believes that Article 19, Clause 6, Subclause 2 mainly deals with the state monopoly. The state is not.
State monopoly. State
State
monopoly.
is not exerting.
Do you have a law saying that there's a state monopoly on education? In your
No,
state?
Your Honor, state is not claiming any monopoly over education sector because the state believes that there should be furthermore innovations within the legal boundaries so that the country
So
can
19
prosper.
goes.
19, yes, Your Honor, the council is stating that the state is not exerting any monopoly over the education sector.
Okay, so 19.6 goes. There is no argument based on 19.6.
The states, the council will say that the state's actions are well within the reasonable restrictions that the state would like to uphold the general public interest. When the state's proprietary materials are violated, the state has the right to file a suit against the Nilgiri Innovations, Your Honor.
Please get on. Make your point.
Thank you, Your Honor. And Article 19, Clause 6 explicitly allows for the imposition of restrictions on the right to conduct business, especially when such restrictions are made in the interest of general public. Additionally, Your Honor, Nilgiri Innovations has gained a dominant position in the market by utilizing the state's proprietary materials to its own advantage, and which is a very clear violation of Section 4 of Competition Act 2002. And the Section 4 prohibits the abuse of dominant position through unfair or discriminatory practices, and Nilgiri Innovations have clearly used the state's proprietary materials through and have gained the unfair position in the market, which will clearly affect the state's general interest and also will undermine the fair competition in the
that another competitor has to come and say that there is cartelization. Where is the another competitor in this case? The state versus.
No, Your Honor.
Where does this Competition Commission and the Competition Act come into the picture in this case? There is the monopolization. They're just using a material.
But still, it is. The council believes that it is still a violation of our proprietary materials, Your Honor. Therefore, the unfair use and undue advantage they have gained is very violative to the
council. Unlike a private party, should there not be an extra fairness in the submissions being made on the part of the state? Yeah, you've been. The state has been saying that. They don't have any such fundamental right, and even if they have fundamental rights, all your actions come within the reasonable restrictions, etc. Part 3, let us forget. Just come to Part 4A of the Constitution. The fundamental duties. It's imposed not just on the individual but on everybody. Directive principles may not be justiciable, but if you comes to the fundamental duties would say that to develop the scientific temper, humanism, and spirit of inquiry and reform. So, could we not approach in that manner, saying that these acts may, though not strictly within the realm of, even though, like you said, that it may not infringe directly, but at least it augments this salutary fundamental duties. Could that not be excused by the state?
Uh, could you please repeat the question? I didn't understand.
A citizen is discharging his fundamental duties.
Okay.
Will the state aid him or stop him?
You should act in a manner that this scientific temper is and the spirit of inquiry develops, and not curtail it.
No, Your Honor, the state as a parent would like to set an example to the public by stating that
So
no,
the state believes in the basic theory that spare the rod and spoil the child.
no.
Please go on, make your point. No issues. Continue in your own pace.
Thank you, Your Honor. Uh, Additionally, Your Honor, the materials in the question are well protected and it can be claimed that the materials in the question does not belong to public domain. As we can under the section 51 of the Bharatpur Copyright Act, the unauthorized use of these materials constitutes copyright infringement, and the injunction and the damage which was awarded by the trial court are entirely justified. The Berne Convention, to which Bharatpur is a signatory, provides that the works remain protected for the lifetime of the author plus 60 years, meaning these materials are not in the public domain. In conclusion, Your Honors, the state's claim are aiming at safeguarding the public interest, ensuring and protecting the state-owned intellectual property. Allowing Nilgiri Innovations to continue using these materials would really, without the authorization, would hinder the state's effort to maintain a competitive yet a fair educational system, where public resources are used for the benefit of the society rather than for the commercial gain of a private entity. Therefore, the Council would like to state that these actions do not infringe, the state's action do not infringe any of the fundamental rights of Nilgiri Innovations, and we respectfully request the Honorable Court to uphold the trial court's decision in the favor of state.
Okay.
Your Honor, if the time permits, the Council would like to state the prayer.
We won't forfeit you of that pleasure. Please do that and make it fast.
Yes, Your Honor. Wherefore, in the light of the issue raised, arguments advanced, and authorities cited, it is humbly requested that this Honorable Court may be pleased to adjudge and declare 1. That Nilgiri Innovations have infringed the copyright claims of the state of Aryavarta. 2. Section 52 of Bharatpur Copyright Act 1957 is constitutionally valid. 3. That the state's claim is neither violating nor infringing any constitutional right of the startup Nilgiri Innovations.
Do we have to declare that something is constitutionally valid?
No, the Council would like to uphold the same, Your Honor.
Next.
And any such order or direction as Honorable Court deems fit and proper, for this the respondent shall duty bound pay.
Thank you.
Thank you, Your Honor.
Yes.
Your Honors, with your permission, can we proceed with the rebuttal?
Yeah, of course.
Okay, the petition side. Petitioner side, you have
Yes.
5 minutes, and respondent side, you have 5 minutes for the rebuttal.
Please.
Petition side can start.
There's a reply to the reply to the reply. Okay, no issue.
Your Lordship, before the council begins, I would like to request Your Lordship's permission for me to represent the rebuttals relating only to the Nilgiri's issue, and my co-counsel to represent the rebuttals relating to the validity of ingredients, Your Lordship.
Even in rebuttal, you have got difference of opinion. Okay, good.
Lordship, we didn't want to have a contradiction with our own arguments which we had submitted.
Okay.
Lordship, with relation to what has been submitted by the state, firstly, there is a very big confusion as to how the state is defending the constitutionality of a central act. That aside, the state has not provided any proper.
You mean to say that the state cannot defend constitutionality of a central act?
Your Lordship, the petition was filed by the other party against the union government. However, they have correlated it to our case as well. And we have not challenged the validity of Section 52. Nilgiri is only.
According to you, the respondents who made the submissions represent only the state government and not the state in the sense like not the union government.
Yes, Your Lordship. They have repeatedly held the same stance as well, that they are representing the state government per se. Your Lordship, and they have also not justified as to how the state material is entitled to intellectual property protection. Council,
just for a clarity,
Council, you were saying that Section 52 is valid.
Yes, Your Lordship.
Somebody supports your argument. Now you want to challenge their locus for that.
Indeed not, your lordship. The council merely was making an observation. That is not my issue to deal with. And
Unnecessary technical objection.
your lordship, the reason I brought it up was that it is an appeal to the High Court. So the questions which are there before the High Court should
I
have been
understand
carried forward.
your argument. Your argument is that the state government could not have represented the union government and answered, but you were a person who was supporting Section 52 all throughout. Your co-counsel
Indeed, yes, your lordship.
gavel on this.
Your lordship, the
We are
council
raising this objection.
Your lordship, the council had stated it because Nilgiri innovation was an appeal versus the state of Aryavata was an appeal in front of the High Court. It was transferred to the Supreme Court. When an appeal is being transferred, new issues cannot be
I
added.
am happy about that.
Yes, your lordship.
See, so far as the Supreme Court is concerned, it has got wide powers under Article 142. You cannot say that, tell the Supreme Court that your lordship should
Much
not.
obliged, your lordship. That is noted by the council as well, your lordship. Lordship, to proceed with the other submissions in relation to the rebuttals, we have clearly established how an algorithm constitutes an idea and not an expression, and how only a program can be entitled to the protection under literary works as defined in the Copyright Act or the Berne Convention or the TRIPS Agreement. But the same has not been substantiated by the respondents as to how their algorithm has received copyright protection. There is no precedent showing the same as well. There is no law supporting the same as well.
Yeah, their contention that even though it was there in the public domain, but specifically there is a caveat that it shall not be used or exploited, commercially exploited. Does that not carry any weight?
Your lordship, we are not, our intention is not to commercially exploit, your lordship. It was there in the public domain. It was absolutely useless as an algorithm.
So, I mean, your case is that you are doing humanitarian activities, but incidentally some money would come in.
Your lordship, as an organization, we don't need money to survive. We are not the state. We don't collect tax from people, your lordship. We are providing educational services, and in return, we are collecting a profit for the same as well. And this profit is going to be used for further innovation, your lordship.
Tax is not consideration.
You are a philanthropic organization,
Tax is
charitable society or something like that.
No, your lordship, the proposition does not go into the details of the same, but our goal is to impart education through innovation in the same, your lordship. And whatever profits we get would be used in the same line of direction as well, your lordship. Your lordship, the state had an algorithm, let it be in the public domain, your lordship. An algorithm is not a finished product, a website or a program or whatever form of method, your lordship.
Your basic contention is that algorithm cannot be copyrighted.
Yes, your lordship. They have not.
You need not, concentrate on that because they didn't really argue that algorithm.
Really not.
So, I mean, you can go to the other point.
Much obliged, your lordship. With relation to the educational material as well, your lordship, they had made an observation that it was published by the state. So the fact that another party is trying to republish it and make a profit.
Council, had your intentions been so noble as attempted to be presented by you, could not have you approached the state or the original owner or the your co-counsel who represents the owners or rather authors and done it in a much more civilized manner instead of taking it out and wasting the time of this court and I mean what kind of a party are you?
Your lordship, the council's submission is in the lines that we are a party which seeks
30
to
seconds remaining.
Yes.
We
are a party seeking to implement innovation in technology, your lordship. The fact that the state's educational material is, even if it was directly being used.
No, let us ask you a simple question. NCERT publishes a book.
Yes, your lordship.
Can you reproduce that book in your name and circulate it, sell it?
Your lordship, the council humbly submit that is not what is happening in the present case. We are merely, so your lordship, the moot proposition clearly states certain educational content. The mere fact that we have an extra set of educational content added onto it. Your lordship yourself observed in the case of EBC, Eastern Book Company versus DB Modec, where if a judgment had merely headers and footers added to it, that is copyrightable. So the same precedent, if we apply here, the fact that we have added our own contribution to whatever is there in the state is enough of us to get copyright protection of our own accord, your lordship. The state is claiming we are infringing upon their copyrights. Much obliged, your lordship.
I think that would be sufficient, counsel. We will hear your co-counsel.
I just, brother, just one question and I'll finish with you.
Yes, Your Lordship.
You say that, the arguments advanced, etc., and our questions were fringing on the fact that the state has not sustained any loss or damage, so cannot. So, could we not invoke the principles of the old case? The classic case Ashby versus White, wherein somebody wanted to vote for someone, he was prevented, but finally that person won. But he was given damages even without injury, saying that his legal right has been infringed. Are you not infringing the legal right of the state?
Your Lordship, the council would like to submit that there is no legal right of the state here being infringed. It is the duty of the state to ensure education. There is no right of the state to have monopoly in education here, Your Lordship. And there is no law. If that is the same, there is no law in substantiating the same as well, Your Lordship.
Right. Let us go to the co-counsel.
You are taking cue from our questions now.
Yeah.
Okay.
Okay. What does the author say?
Yes.
Much obliged, Your Lordship. As already stated by by the Council of Nilgiri Innovations, I would like to state it again. So the Supreme, as given in the moot proposition, the Supreme Court has compiled various petitions under Article 139A, Your Lordship. As the issue constitutes the question regarding the constitutionality of the Bharatpur Copyright Act 1957, it is the Union of Bharatpur that must have been appeared before this honorable court, Your Lordship, and not the state of Aryavarta, Your Lordship. The petitioners would like to get the clarification from the respondents regarding why the state of Aryavarta has appeared instead of Union of Bharatpur, Your Lordship.
Are you challenging
Also,
the constitutionality of Section 52?
Yes, she is. Because the funny aspect is that she move. Council moves along with the Writers Guild moves along with the state as far as that is concerned.
My next
But
question: why are you challenging it?
yes, Your Lordship, as we are representing the Scholars Alliance, which encompasses the group of
So
authors.
suppose Section 52 goes, will it be in your favor or will it be in the state's favor?
State's favor. If it goes, it will be in our favor, Your Lordship.
How?
then they'll have absolute control according to you.
Not absolute, but as not stringent
Better
as it is
control.
now.
Okay.
Yes, Your Lordship. Better control.
Anything more?
That's obliged, Your Lordship. Also, moving to the contention stated by the Learned Council of Respondents, the only the U.S. copyright law as fair use, which prevents use for prevents use of commercial purposes, Your Lordship. In contrast, our law based on UK law allows broader usage of fair dealing, Your Lordship. Hence, also reading through the section 52, certain acts not to be infringement of the copyright. It includes fair dealing with any work not being a computer program for the purposes of private or personal use, criticism or review. The report of
We take your point. You are coming back to section Shreya Singhal and all that. It's equally placed, so this has to go. Fine. Anything else?
Yes, Your Lordship. In that particular point, as stated in the section, there is no neither explicitly or implicitly prevent the commercial usage of the commercial usage, Your Lordship, which shows that the provision is both unconstitutional and outdated. The petitioner seeks clarity on the same, Your Lordship.
So you are only on a matter of principle. You are not sustained any loss, damage, etc. You are not seeking any damage. You are not seeking any injunction. You just want to protect the members' right by getting 52 abrogated or declared unconstitutional. That alone is your proposition. Okay.
Yes.
Okay.
Is there any reply on the side of the state again? I don't know. Does the rule say so?
No, actually, I think we can conclude this, is it not?
Ejas, anything else?
Normally, they are usually
respondent-
limited to have a sub-rebuttal part unless they don't want.
Does the
Does the
respondents
state want to submit?
The
want
other
the sub-rebuttal?
They are not
But they-
going for a sub-rebuttal.
Okay. If they
No
don't have a
problem.
sub-rebuttal, we can proceed. With
Then
the,
we can conclude.
we can conclude.
Does the state want to say anything more?
That is no sub-rebuttal. They have closed.
No, the state has been silenced. That too in this apex court. Very, very unfortunate. The state is not willing to.
Your Honor,
Ah.
there's a slight clarification that we need to make. The
Sure.
opposite, the opposite council has spoken about Scholars Alliance, but Scholars Alliance, the case of Scholars Alliance is silent in the moot proposition, that they have taken an entire contention, or entire speaker has spoken from the point of view of Scholars Alliance case. That is that is a slight
Can I switch
clarification.
on your camera, respondent side speaker?
It's a ghost presentation.
I'm so sorry, Your Honor.
It is because both these cases are being heard together. They have split those issues between themselves, and they said that one will be representing the company, the startup is not able to afford two counsel at the Supreme Court like the state. So they have come with one counsel, the other the scholars have engaged. What is wrong in it?
Your Honor, they've assumed that Scholars Alliance upholds underprivileged category, but the moot
There's
proposition.
nothing like that. They are only challenging Section 52 to say that the provision is unconstitutional to the extent it gives some permissive usages in violation of the copyright. That's
But Your Honor, Your Honor, how does Nilgiri Innovations is connected to this section?
It is because you filed a suit and brought them to the High Court. That High Court has now been pulled. I mean, that case has been pulled to the Supreme Court by us. It is all our own creation.
The state should understand that we had to suffer their arguments only because you brought them into the fray.
Anyway, do you say that are you representing Union of Bharatpur?
No, Your Honor.
You are not representing Union of Bharatpur.
We are representing state of Aryavartha.
What?
Anything else?
No, Your Honor.
Thank you.
Thank you so much. It was a pleasure listening to us.
The participant can leave, and I request the judges to take that.
Thank you, Your Lordships. It was an honor arguing before this court.
Thank you.
That feeling is mutual.
Thank you, Lordship. It was a pleasure arguing before this court.
Thank you.